Good evening, ladies and gentlemen. Welcome. Can you please rise as we welcome the procession inside the venue? Thank you.
Goeienaand almal, good evening, Mweni. Welcome to this inaugural lecture of our colleague Professor Theo Broodryk. It is my pleasure to welcome in particular representatives of our institutional management, trustees from the Faculty of Law Trust, colleagues from other faculties and universities, colleagues, friends and students from our very own Faculty of Law, as well as SRC members, the honorary guests of this evening, of course, Professor Broodryk and his family, in particular, Professor Broodryk's wife, Marlene, also an alumna, his parents, David and Yvonne Broodryk, as well as his brother and sister-in-law, Marcel and Nina Broodryk. Welcome. Professor Broodryk took up the permanent position as manager of our Stellenbosch University Law Clinic in 2013, or rather 2017, apology, the same year that I joined this Faculty of Law. And it is therefore a very special pleasure for me to introduce Professor Broodryk tonight. Theo Broodryk is a professor of law at Stellenbosch University. He obtained his degrees, the BA, LLB and LLD qualifications from Stellenbosch University. He is an admitted attorney of the South African High Court, having previously practiced at Africa's largest law firm. Moreover, he is a senior researcher, for example, at the Jus Commune Research School in the program Foundations and Principles of Civil Procedure in Europe. He's a Beaufort Colenso Fellow at St. John's College, Cambridge, and previously attended Stanford Law School as a visiting scholar. Professor Broodryk has received numerous funding awards, including the MJ and H.B. Tom Research Award and an NRF Knowledge Interchange and Collaboration Award. In 2020, he was honored with the prestigious George Foster Fellowship Award of the Alexander von Humboldt Foundation in Germany. Professor Broodryk is a certified arbitrator of the Association of Arbitrators Southern Africa, and he holds a Y1 rating from the National Research Foundation. In addition, he currently serves on the South African Rules Board for Courts of Law. He has authored leading publications in the field of South African civil procedure, including Eckart's Principles of Civil Procedure in the Magistrates' Courts, and is also involved in various international projects, including co-authoring a segment on collective litigation and the protection of non-litigants' interests as part of a compendium of comparative civil justice under the auspices of the Max Planck Institute for Procedural Law. Professor Broodryk has succeeded to expertly fulfill the role of manager of the law clinic in concert with his role as senior academic, leading the Issue Law Clinic team to be recognized as South African social justice law firm, as well as the South African Specialist Law Firm of the Year on several occasions. I want to conclude this brief introduction by reiterating that it is not always the case that we need to do more, but rather that we need to focus on less. As Alexander Graham Bell said, concentrate all your thoughts upon the work in hand. The sun's rays do not burn until brought into focus. Our colleague Theo's career progression clearly illustrates the rewards of being both a prolific but very focused researcher, lecturer, and social impact leader. We are indeed very proud for you for reaching this milestone, Theo. This occasion of an inaugural lecture, if I may remind you again, not only provides our faculty and the university with a platform to recognize the status and expertise of a senior academic member, who now is recognized as a professor of law, but it is also an occasion for scholars to showcase their academic journey over time. And it is special because it is a rare opportunity to share this professional milestone with an audience that includes family, friends, students, and colleagues. Finally, an inaugural lecture is an opportunity to increase awareness regarding contemporary topics, and tonight's topic deals with such a matter, namely 30 years of class action in South Africa and the potential for collective redress. I would like to invite Professor Broodryk to the podium to please deliver his inaugural address.
Thank you, Dean, and good evening, everyone. A multinational technology company that designs, develops, and sells consumer electronics admits to slowing down some of its older cellular phone models through the use of a degraded battery. They explain that this was done to avoid unintentional shutdowns of the cellular phones as the batteries aged. Consumers are forced to incur expense to replace the batteries to avoid these intentional slowdowns. Do these facts sound familiar? Yes. They of course resemble the facts of the iPhone Batterygate scandal. Consumers who form part of the class action against Apple in the United States in 2020 have recently received their piece of the settlement payout, amounting to $92 checks per individual iPhone owner. Similarly, in Canada, the class action against Apple have been settled for an amount of between $11 and $14 million, amounting to individual iPhone owner payouts of $150 per iPhone owner. No similar proceedings have ensued in relation to the iPhone Batterygate scandal in South Africa to date. Roundup, the weed killer, distributed for both personal and commercial use. I'm sure that many of you would have used Roundup at some stage to kill those pesky weeds in your garden. Lawsuits have been filed globally by individuals and classes of individuals alleging that Roundup causes cancer. More than 100,000 lawsuits have been settled globally, amounting to settlement payouts in excess of $10 billion US. Currently, there are 30,000 lawsuits pending. No similar proceedings have ensued in South Africa to date relating to Rana. Scenarios such as these have forced me to grapple with the question, why is it that we as South Africans don't litigate collectively more often? Why is it that after 30 years of class action in South Africa, South Africans seem to be a people inured to hardship, but not to collective redress? This is the question that I'm going to explore during tonight's lecture. And to do that, I'll structure my lecture as follows. Firstly, I'll provide a bit of information that I think is relevant to contextualize the discussion relating to the reasons for the underutilization of the class action that follows. I'll also provide you with reasons in support of the increased utilization of the class action in South Africa. And then finally, I'll share my sentiments as to why I think a sea change awaits the South African collective redress landscape. There are 6 important considerations that are relevant to contextualize the discussion pertaining to the underutilization of class actions in South Africa. Firstly, it's important to understand what a class is. What does it mean? Well, a class action is a civil procedural mechanism which allows for the claims of a group or a class of persons to be consolidated into a single lawsuit. The claims of those groups of individuals are determined in the single lawsuit against the same defendant or defendants. The class representative institutes the class action on behalf of the class of persons. The class representative is described as a party to the litigation. The class members are not parties to the litigation, but they are bound to the judgment on the common issues in the class action. Whether favourable or adverse, the judgment in the class action is re judicata in relation to the class members, regardless of actively participate in the class action. Secondly, South Africa's class action was introduced through the interim constitution in 1993. The final constitution in section 38C now provides for a basis to institute class proceedings when the class action is premised on an infringement of constitutional rights. Importantly though, our courts have recognised a class action outside of the ambit of the Constitution. In other words, where no constitutional rights are implicated. For example, a consumer class action. Thirdly, no legislation exists that regulates class actions in South Africa. It's been left to our courts to develop a framework to regulate the mechanism on a case-by-case basis. I'll return to this issue a bit later. Fourthly, a class action consists of 2 parts. The first part is the class representative bringing an application for certification. The first part is certification of the class action. Without certification, there cannot be a second part, which is the class action itself. Certification is a precondition for the class action to commence. Fifthly, there have only been 21 judgments in which the superior courts of South Africa have definitively pronounced on whether a matter could proceed as a class action. And where it's clear from the papers that the parties intended to frame the matter as a class action. Stated simply, there have only been, over the past 30 years, 21 certification decisions by South African superior courts in class action proceedings. Finally, our class action mechanism is modelled on class action mechanisms of prominent foreign common law jurisdictions, including Ontario in Canada and the federal class action mechanism in the United States. The class action mechanisms in these jurisdictions are used much more frequently. For instance, in Ontario, with a population of 15 million people, between the period 1993 and 2018, more than 1,500 class actions were initiated in Ontario. During the same period, there were 12 certification decisions in South Africa. In the United States, it's estimated that more than 10,000 class action lawsuits are filed annually. Although the US has a population of in excess of 340 million people, the data clearly indicate that the mechanisms in these jurisdictions, the collective redress mechanisms in these jurisdictions, are utilized much more frequently than our mechanism. And that brings me to the primary question that's subject to consideration tonight. Why don't we litigate collectively more often? I would like to advance various reasons to explain why I think our collective redress mechanism, our class action mechanism, is not utilized as frequently as it should. The first reason that I'd like to advance is the failure by our legislature to regulate the mechanism. The failure by our legislature to regulate the mechanism. It's resulted in our mechanism being viewed and used with caution. I've mentioned that our mechanism was introduced more than 30 years ago, but still no legislation has been enacted to regulate the mechanism. It's been left to our courts to develop the framework within which class actions are adjudicated. And they've done commendably well. But it's not ideal to leave the development of a framework regulating class actions exclusively to the court. It's not ideal to address procedural complexities as they arise on a case-by-case basis. It may, for instance, result in inconsistent judgments by the various divisions of the High Court of South Africa. This has proven to be the case, for instance, in relation to the issue of whether it's necessary to certify a Bill of Rights class action. Various divisions of our superior courts have come to different conclusions as to whether certification of Bill of Rights class actions is necessary. The absence of clear regulatory legislation also makes it difficult for individuals and businesses to assess their risks, especially their legal risks. And it creates a legal vacuum, leaving certain issues unregulated. For instance, until very recently, the issue of whether it's possible to appeal a decision certifying a class action was left unregulated. It was unclear whether it's possible to appeal a certification decision. The prospect of an applicant bringing an application for certification and being successful with certification, but being bogged down in appeals of the certification decision is certainly an unappealing one. The class action has not even yet commenced. That's proven to be the case in the context of, for example, the consumer law class action instituted by the Stellenbosch University Law Clinic, where the certification application was instituted in 2009. Certification application was successful. The decision has been appealed to a full bench of the High Court, to the Supreme Court of Appeal, and to the Constitutional Court. Although all appeals have been unsuccessful, it's 2024 and the class action has not yet been instituted. So the prospect that an applicant could succeed with certification but could be bogged down in appeals is an unappetizing one. And therefore, I believe that these are issues that should be addressed within the confines of a clear legislative framework. And this has proven to be the case in various prominent foreign jurisdictions, including Ontario and the USA, where in the USA, in Federal Rule of Civil Procedure 23, there's a clear provision regulating appealability of certification orders, as is the case in the Class Proceedings Act in Ontario. The absence of legislation has therefore, in my view, clearly contributed to the underutilization of our class action mechanism. I mentioned earlier that there have only been 21 certification decisions over the past 30 years. Only 10 of the 21 certification decisions resulted in certification of the class action. This is a certification rate of just over 45%. The certification rates in the US and in Ontario are significantly higher, bordering on 70%. I believe, secondly, that one of the reasons for the underutilization of our class action mechanism is the stringent approach adopted by our superior courts during certification to determine whether the cause of action raises a triable issue. Of the 11 certification decisions in which certification was denied, 6 of those decisions related to the cause of action. Our Supreme Court of Appeal has adopted the following position to determine whether a cause of action is legally untenable. They've held that the approach that needs to be adopted is to apply the test relating to exceptions to determine whether the cause of action is untenable, whether it raises a triable issue. That also entails, then, as part of the exercise, determining on all possible interpretations of the facts whether a cause of action is disclosed, taking the evidence available at certification stage into account, and also estimating what evidence might potentially become available during trial preparation, for example, through a process such as discovery. I've argued for a much less rigorous approach to be adopted during certification. I argue that an approach similar to the one adopted in Ontario needs to be adopted locally, which entails simply determining whether it's plain and obvious that the cause of action is untenable. If it's plain and obvious that the cause of action is untenable, then simply the class action should not be certified. But if it's not plain and obvious that the cause of action is untenable, the class action should be certified, and the trial court, in other words, the court that's burdened with the class action itself, should be responsible for determining whether the cause of action is excipiate, and only if the defendant raises an exception at that stage. The low rate at which certification applications are certified by our High Court is fueled by our court's stringent approach to determining the legal tenability of a cause of action, and has therefore probably also dissuaded the utilization of class proceedings amongst putative class representatives and class members. Thirdly, an obvious one, I think. There are not enough class action lawyers in South Africa. At most, there's only a handful of lawyers who specialize in class actions. And I think the reasons are obvious. Class actions are extremely financially demanding. and resource intensive. The costs associated with the giving of notice, the preparation of expert witnesses, engaging in the discovery process is significant. In fact, it might be prohibitive. One could understand, therefore, that the financial implications of a class action could dissuade potential applicants from bringing an application for certification of a class action. Class actions also involve high stakes and can be very risky for law firms to take on. In fact, if the law firm is unsuccessful in class action proceedings, it's very likely that they'll be unable to recoup their investment of time and resources in the litigation. That obviously then serves to limit the number of law firms that is willing to take on class actions as a part of their core business. We've also seen that, considering the current data at our disposal, that more than 50% of certification applications are unsuccessful. More than 50% of certification applications are unsuccessful. We're not even talking about the class action yet. One can understand that law firms might be dissuaded from taking on these large-scale matters. Handling class actions also require an exceptional commitment to ethical standards. Why? Because the interests of a large, absent group of individuals are at stake. It's also possible that conflicts of interest arise in the context of class proceedings that could prevent law firms from taking on class actions. All these reasons contribute to the underutilization of the mechanism. Fourthly, although I have no doubt that third-party litigation funding will become a core significant feature of our litigation landscape in future, we are certainly not there yet. Litigation funding is not a key part of the South African civil litigation landscape at present. It's trite that the absence of litigation funding has a direct impact on the number of class actions instituted annually. As I've just mentioned, class actions involve significant costs, and without litigation funding, individuals or groups may be deterred from pursuing class actions due to financial barriers. This can limit access to justice for those individuals who cannot afford the upfront costs of the litigation. The absence of litigation funding may mean that fewer class actions are brought, and this would in turn reduce the overall deterrent effect on corporations and entities and individuals from engaging in the wrongful conduct that forms the subject of the class proceedings. Litigation funding can also influence settlement dynamics. If the plaintiff has the necessary financial means to pursue the class action, then presumably they'd be willing to proceed to the class action stage of the class proceedings. However, in the absence of having the necessary funding to engage in the litigation, plaintiffs may be more inclined to settle at an earlier stage of the litigation on less favourable terms because of financial pressures. The experience has been that in jurisdictions where litigation funding is limited or unavailable, the environment for class actions is less conducive and fewer class actions are instituted. This has proven to be the case in South Africa to date. Not worth it. Class actions are often used in the context of economically non-viable claims. Those are claims that are so small that it's unlikely that the individual class members would have litigated independently to recover their losses. It's especially in this context, economically non-viable claims, that we see the waiting for God-it attitude prevail. South Africans are notoriously patient when it comes to suffering injustice, and we are often reluctant to engage in self-assertion in the face of threats and disaster. We have a desire to be led, and we see this in the collective redress space as well. Someone else needs to take the collective redress lead. It's not going to be me. I acknowledge that cultural attitudes and social stigma may impact on individuals' willingness to pursue class proceedings. But nevertheless, in the economically non-viable claim recovery space, class proceedings are underutilized because individuals are reluctant to take action. A further reason for the underutilization of our class action is the lack of education and empowerment of South African citizens, especially the impoverished, relating to class actions. Legal empowerment helps to improve access to justice. Access to justice includes having access to a court, but it means more than simply having a right to approach a court. It means having the ability to do so, having the skills and the resources to enforce those rights. More than half of the South African population, so 30-odd million people, live below the upper poverty line of 1,558 rand. If we take into account that our class action is mostly being used where the classes comprise the poorest portions of society, if we also take into account that the primary objective of our class action mechanism is to facilitate access to justice, then the lack of education and empowerment of South African citizens have certainly also contributed to the limited number of class actions instituted to date. In my conclusion, I'll speak about education and empowerment very briefly. There are numerous other conceivable considerations that could play a role insofar as the underutilization of our mechanism is concerned. For example, the geographical dispersion of class members might present management difficulties insofar as communication with the class is concerned. It might be difficult to give notice of the class action. That might present management difficulties, which might militate against certification. It is, after all, a consideration that is relevant during certification. That might deter the institution of class action proceedings. Perhaps a more disconcerting reason for the underutilization of the class action is South Africans slowly eroding trust in the South African judiciary and judicial system. This trust in the judiciary can undoubtedly undermine confidence and fairness in the efficacy of the legal system. It could lead to the underutilization of mechanisms such as class actions for addressing systemic grievances and seeking to address collective harms. But you've probably at this stage wondered, why is it necessary for our class action to be increasingly utilized? Why is it important for the class action to be instituted on a more regular basis? Let me briefly provide you with a few reasons in support of the increased utilization of the class action. Class actions allow multiple individuals with similar claims against the same defendant to consolidate their claims into a single lawsuit. In other words, it promotes judicial economy. It prevents our court system from being overwhelmed with numerous individual lawsuits with similar factual matrices. It saves time for both the court and for the parties involved. The class action also facilitates access to justice by providing a mechanism for individuals who may not have the financial means to institute proceedings to form part of a collective action. It ensures consistent judgments for similarly situated plaintiffs. When multiple individuals have similar claims, consolidating them into a single lawsuit helps to avoid the possibility of inconsistent rulings that may arise from separate lawsuits with similar facts. As mentioned, class actions can have a deterrent effect on companies and entities engaging in wrongful conduct. The potential for a large group of plaintiffs to bring a unified legal action can make wrongdoers think twice before engaging in actions that could hold significant financial and reputational consequences. Ultimately, class actions can be a catalyst for systemic change by addressing widespread issues that affect large numbers of people. Successful class actions have the ability to change corporate behavior, to affect industry standards, and to improve regulatory practices. The final part of my lecture entails briefly considering what steps must be taken to move towards the increased utilization of the class action. I'll also briefly comment on why I think a sea change awaits our collective redress landscape. A detailed legislative framework is an essential step towards the increased utilization of our class action. I was fortunate to, at the Rules Board, recently lead the drafting of a rule that will be imminently inserted into the Uniform Rules of Court. The rule regulates class action certification. Although it's limited to the certification component of class proceedings, I believe that it will contribute to promoting legal certainty insofar as the utilization of the mechanism is concerned. Ultimately, the new rule will make it easier to file and maintain class actions while safeguarding against abuses. Secondly, there needs to be increasing legal education and awareness regarding class actions. When individuals are informed of their rights, they are more likely to recognize instances where collective action is appropriate and warranted. Empowered communities are more likely to come together to address common grievances and seek legal remedies collectively when they've been educated and empowered to use the class action mechanism. It can lead to an increase in the number of class actions as communities recognize that their strength lies in their numbers. Legal empowerment initiatives can also serve to remove some of the barriers that present themselves when individuals want to pursue legal action. And these barriers include financial constraints, a lack of legal representation, and being confronted with procedural complexities as part of the litigation process. Legal aid organizations and private law firms should be incentivized and empowered to institute class proceedings or to support class actions, particularly in cases where individuals might not have the means to pursue litigation on their own. Perhaps a more controversial submission is that the risk of inconsistent approaches by different divisions of the High Court of South Africa should be reduced by exploring the effect that the creation of a single High Court has had on judicial precedent. Currently, the different divisions of the High Court do not seem to consider themselves bound by the judgment handed down in divisions other than their own. However, following the rationalisation of the High Court through the Superior Courts Act and the Constitution's 17th Amendment Act, there is now a single High Court of South Africa. The judgments of the various divisions of the High Court should be bounding upon one another. This will serve to reduce the risk of inconsistent judgments arising, not just generally, but specifically in the context of the collective redress space. Finally, we need to more aggressively leverage technology to improve communication with potential class members, and we need to enhance the administration of class actions, making the process more accessible and transparent. Matters that are susceptible to class action should also be more determinedly advertised. Ultimately, I believe a sea change is upon us. Never before has there been as many class actions pending before our superior courts as there currently are. They include class actions relating to health damage caused to coal miners, a Vagina class action, class proceedings relating to the Jagersfontein mine dam burst, a class action against the police ministry relating to cop smuggled firearms, a class action related to negligence on government's behalf relating to the provision of contaminated water which resulted in the death of 23 Amansal residents, a class action relating to damages suffered by thousands of ignorant taxi owners who were sold fake Toyota Quantum Sisfikile taxis. These are just some of the examples of the class actions that are currently pending before our superior courts. We have seen that the experience in the prominent foreign jurisdictions where class actions have been established for some time now, the experience has been that the more class actions there are, the more people become aware of the mechanism, and the more likely they are to use it. The more inclined they become to use the class action mechanism. The more cases there are, the more developed the law becomes. And the more crystallized and the more certain the legal framework becomes. The more cases there are, the more third-party litigation funding becomes involved funding class proceedings. And as I explained, the more third-party litigation funders there are, the more class actions are likely to be instituted. As we reflect on the South African legal landscape, it's evident that a transformative shift towards the enhanced utilization of class action is not only desirable, it's imperative. The potential for collective legal actions to address systemic injustices, to protect the rights of marginalized individuals, and to promote accountability cannot be overstated. Embracing the power of collective unity in the pursuit of justice will undoubtedly strengthen our legal system and contribute to a more equitable society. As we embark on this journey, we should champion the cause of collective empowerment, specifically through the use of our class action mechanism, recognizing the capacity of the class action to redress imbalances and to pave a way for a more just and inclusive society for all citizens. Hopefully, it will assist in propelling South Africa into an era where justice is not merely an illusory concept, but a lived reality for every member of our diverse and vibrant society. And I believe the class action has the potential to do that. Thank you. I know Professor Pienaar will speak a few words of thanks. I would like to monopolize the platform for just a couple of more minutes to thank a few individuals specifically. As I reflected tonight on my academic journey at the faculty over the past 10 years or so, I was reminded of the meaningful roles played by various individuals at different stages of my career at the faculty. Without the contribution of these individuals, I would certainly not be here tonight. So I'm very thankful for the roles played by these individuals. I'm privileged to work at a law faculty with extremely caring and supportive colleagues. But I'd like to thank a few of my colleagues in particular. Professors Theo Quino, Jacques du Plessis, Juanita Pienaar, Sonia Iman, and Bernard Wessels. Thank you for your contribution to my professional development and career progression. I'm deeply grateful for the role that you've played. I'd like to thank our Dean of Law, Professor Nicola Smit, for her contribution, her guidance, and her unwavering support. Professor Smit is an incredibly strong and selfless leader, someone who seeks to empower those around, and we're very grateful to have you as our leader. I would like to express my gratitude to Professor Wouter de Vos. I have an incredibly high regard for your work, not just generally in the field of civil procedure, but specifically in the class action space. And your guidance and your mentorship throughout my career has had a lasting impact on me, and I'm extremely thankful for that. To the remarkable individuals that make up the law clinic team, and I see the faces scattered there at the back, I want to extend my deepest gratitude. Your unwavering commitment to our mission, your passion for justice, and your tireless efforts to empower those in need have not only enriched the lives of countless individuals, but it's also enriched the fabric of our institution. So to my attorney team, Dr. Stephen van der Merwe, Nikita Standard, Josie Parks, Odwan Weber, thank you very much. Sharon Smith, our administrative manager, Martha Esso and Priscilla Kani, our receptionist and administrative assistant, and the rest of the law clinic team. I'm extremely grateful to have you as colleagues. As I stand here before you today, I do so with profound humility and gratitude for the love and support of my family. Your sacrifices, your encouragement, your unwavering belief in me has made this moment possible, and for that I'll be forever thankful. To my wife Marlene, your boundless patience and your steadfast belief in me have been a constant source of pain for you, but strength for me. Thank you for always supporting every career decision that I've taken, even where it might have come at your expense. And then finally, to my 18-month-old son, David, in his absence, a request, I think a desperate request, albeit likely futile. Please, can we have some rest tonight? Thank you.
Dean Nicola Smith, Vice Dean Richard Stevens, Vice Dean Juanita Pienaar, staff, students of Stellenbosch University and other campuses, alumni, emeritus colleagues, societal partners, guests, friends, and family of colleague Theo, especially his spouse Marlene, And I just heard about David, who will sleep soundly tonight. And also your parents, Theo, and siblings present here tonight. I have a wonderful mandate. I must hand this certificate to you just now and do it on behalf of the university and especially the Senate of University as our central academic body. They have all agreed that you deserve to be a full professor of law. Can we applaud our professor? Full professor is the top academic position at this university as well. And henceforth, colleague, you will as a full professor continue to do the work that you reflected upon tonight so extremely well. You will also fulfill your calling as full professor guided by values like the e-care values of Stellenbosch University, which means you will continue doing it with excellence, with giving your best in terms of your specific potentialities and opportunities. And you will do it, continue doing it with dedication, with determination, with a sound work ethic. You will secondly fulfill your calling with compassion, as we could witness tonight. You tonight demonstrate to us compassionate justice, justice that grows from a head and a heart and hands of sympathy, feeling with others, of empathy, feeling yourself into the skins of others, especially marginalized and suffering and wronged others. And also with interpathy, meaning that you don't just feel yourself in, but you also think yourself over boundaries into the so-called other and the plight of the other. So it's excellence, compassion, but also accountability. To say what I do, I will give account of. I will be transparent. And I know transparency serves truth and truthfulness. Transparency serves trust and trustworthiness. You will also adhere to the value of respect, in a sense to say, put on your spectacle again. Look again. Think again. Consider again. Do I advance the dignity of somebody by my words, by my actions, by my interventions? Or do I violate their dignity, respect? And lastly, equity. From the Latin quietas, to say we want to build societies of equilibrium, where some don't have too much and others too little. Equity also in the sense of level-headedness, to guard against extremes, to seek fairness, to manage complexity, complexity in all its forms, like plurality and ambiguity, ambivalence and duality, paradoxality, and even treachery. We have seen over the years knowing you, Prof. Theo, so much of embodiment of these values in your person and word, and we've witnessed to it tonight again. We really look forward to continue this great journey with you. And tonight I must say, as somebody also working closely with you in social impact, it is great that Stellenbosch University can have in its service full professors like Professor Theo, Broodryk. Baie dankie, collega.
Good evening. I have the best job, and that is the vote of thanks. It's very special for me to be able to do that. When Theo joined the faculty in 2014, the year after that, 2015, I became the head of department, and I immediately realized we are dealing here with an exceptional colleague, with a lot of passion and enthusiasm. And it was just a matter of time that we would have an inaugural lecture, and here we are tonight. Theo, that was a wonderful address, definitely not a stuffy old lecture. It was a calm, lovely address, well done, as always. There's a lot that needs to happen before we can have an evening like tonight. So while Theo was hard at work preparing and writing his address, a lot of administration and logistics had to be dealt with as well. And it is in that light that Theo asked me to extend a vote of thanks to the following persons. First of all, Jonathan Dale Blankenberg and Amira Brown for all the arrangements that made tonight possible, as well as the other members of the inaugural working group. Thank you very much. Prof. Nico Koopman, the representative of the Rectorate. It's always lovely to have you here, Nico. Thank you for your presence and for your kind words. Ignis Dreyer, he was the photographer tonight. We know his work, and he will work his magic as usual, holding fast. And then closer to home, our own staff members, who did a lot behind the scenes. Yolandi Philander, the Dean's PA, thank you for your hands-on assistance, as always. And then also Gerda and Kathy Adams for all the work behind the scenes. And then finally, it's lovely to have all of you here, our colleagues, staff members, former staff members, the trust, practitioners, the law clinic, and also students. Thank you for taking the time. I know there are also people participating online. Thank you for your virtual participation. We had a lovely evening, but it's not finished yet. So I would like to extend an invitation for all of us, for you to join us for drinks and refreshments. It's not in the quad, but you will see exactly where the action is. And then Theo, in your address you mentioned our inherent need to be led. So I'm inviting you to lead the procession. We will all follow. So if the audience can please stand. Thank you. Have a good evening.